That's fine. So this is just to summarize. But, I'll take your lordship to some parts of the CC report, but we believe this, Malad, some clarification needs to be given by the CC. The CC report recommends the deletion of Zurpi jungle lands allotted up 6 from the list of forest areas. This applicant has a fundamental objection to treating 12-12-96 those lands which were already as forest only because the aforesaid ruling came on a subsequent date. It is a matter of record in the present case that a decision was taken by the MOEF as far back as 12/2/1992 of IA so and so, Malad, this is on record, to continue to treat, Malad, please note the words, in fact it says to continue to treat Zulfi jungles because the state of Maharashtra at that stage was taken a unilateral decision that these lands should not get,
out of air.
Please, I'll just read on.
So if your condition is to be accepted, the High Court, the High Court building at Nagpur will also have to be demolished.
Not at all. I'll explain.
It is that all those lands which were used already Vidarbha, the primary health centers, the Anganwadi. Jilapis will all have to be demolished too.
I'll just, 1980 is according to us the cutoff date. Whatever came before 1980, we have nothing to say at all, Manoj. Nothing to say. Your Lordship may note that. But we are questioning, Manoj, ultimately Goda Burman decision, it expanded the meaning of forest. We can't use it to say, no, now only from this date it will be. So, Manoj, that may be considered, that is one aspect.
So therefore,
see, two, Manoj, NPV is being dispensed with. There is no basis, number two, I'm reading, Manoj. There is no basis for an exemption from NPV. Such a recommendation not only has the effect of denying the center funds which can legitimately be used for the purpose of
purchase of iPhones and
I'm sorry.
For the purchase of iPhones and other gadgets.
Well, but this also
the client without and you are arguing without
I'll show from the report. What you are saying. Look, please see further. There can be no justification for the proposed plan for ex post facto clearances and deeming fiction that all activities will be considered site-specific. That I can, these, some commercial buildings, etc. have come up, which are treated as, of course, encroachments. But other types of buildings have also come up after this cut-off date of 1980. Please consider. Then 4. 4 is the report fails to identify any pockets or stretches of land where there are critical habitats or wildlife corridors. Only to these.
There are no critical habitats there. They are all the cities now.
They must say that there will be some stretches, there are corridors. But they must identify that, all right, these are corridors. Find so and so dry deciduous scrub forest. Which is their recommendation. There will be no indexing of FC clearances with this. Within a wildlife corridor or maybe ecologically sensitive, the CEC has failed to take into consideration plots falling within ESZs. In respect of para 7, I can show this. It is submitted that the stand regarding settlement of rights is an acknowledgement that then please see 8. There appears to be an error, There is an error. Obviously, I take it there is a are being treated as par with encroachments. There is no clarity on what commercial purpose.
To be appointed for identifying such posts. You can't expect the CEC to go in every village and identify these things. So I think there is a recommendation, Mr. Parmeshwar, that the so far as the revenue lands which are recorded as forest and in the possession of revenue, we are concerning that issue in retreating. See, that will hear you out my opinions. Yes, madam.
Why not 1980? Why not? Because 1992, Government of India, MOEF has taken a very clear stand that you cannot do this. 1992, and the Government of Maharashtra, they withdraw their decision in view of that. Not that they could have taken it unilaterally. But obviously, 1992, MOEF takes a decision. Why then?
constructions which is done for the public purposes. They are not recommendation. They are not recommend regularization of the encroachment and commercial. And insofar as the commercial will.
There was lack of recognition that the actual errors are not recorded as certified as first. We cover the.
We'll hear you on 19th. We thought that so that you are aware on the next day as to what are their concerns, and we can address them in the next day. Yes.
They can geographically point out some identification because there must be, these tiger habitats are also not far from these areas. There would be critical corridors which are being used. If they can identify that, perhaps the problem can be solved.
Yes. They are through completed this, no?
This is the two-page submission that we have.
Yes.
So we share it with the other side.
You share it with the learned Amicus as well as the CEC and the state government also. Give a copy to them so that ask them on the next day as to.
Identify because we do not know what are those commercial buildings, whether they are commercial.
It's very difficult for CEC to do it. That physical exercise, it's on such a vast expanse. Therefore, we'll do something like constituting a district level committees and all that. Consider this.
Thus, this also and put forth the suggestion.
You just get this note to the ACS for 2 days. You do only Uttarakhand is left.
Yes.
Where is this Unchaja Shukla? Yes.
I tried to get in touch with him. He's saying he's in hospital. His father is unwell, and I'm unable to get in touch with the concerned standing council either. My apologies, my lords. My lords, may please have it on Friday or the next.
We'll get the chief secretary on 19th.
I quite see, my lords, it is embarrassing, and I unfortunately, my lord, I'm not the concerned you are, otherwise I would have assisted my lord. My lord can have the matter on Friday or my lord on the next. And I will personally, my lord, inform the chief secretary. My lord will not summon her.
By order dated.
Malus, may I submit, Malus? Just a moment, Malus. Malus, I was not unmuted, Malus. I am advocate on record in this matter, Malus.
Yes. Have you finalized it as per our directions?
Malus, we are filing 2 compliance affidavit today, Malus, since your lordships have granted us time for till today, Malus. So we have got the affidavit, Malus. So filing it, Malus. When is the last date of compliance, Malus? We have got the affidavits, Malus. We will be filing during course of the day.
5th of February 2025. Yet, directed the state to complete the formality. Well, EFZ of both Rajaji National Park and Jim Corbett National Park within a period of 2 weeks from the date of the said order. Where is your compliance report?
Malas, we will be filing today. Malas, we have got the, please, Malas, we have got the affidavits. Malas, since your lordships have asked us to file till 5th, Malas.
Kept the matter today also.
Please, Malas, we will be filing it today also.
You have noticed it now.
Malas, since the matter was not listed, Malas, we were not under this impression that it will be taken up. But we are filing Malas compliance affidavit today itself.
Who is saying that the matter is not listed?
Malas, since the time was granted till 5th, Malas, I apologize, Malas, for the inconvenience, but we are filing it today, Malas.
Is it done or not? That's your question.
Malas, I have got that, Malas, in a process within an hour or so, Malas.
Have you not read it?
Please, Malas, I have read them, Malas.
So whether it is complied with or not, that's the question that we are asking you.
Malas, we have pointed out the difficulties, Malas. We are asking some more time since, Malas, there are some procedural aspect is, Malas, that has to be gone into. And therefore, Malas, we are asking any reasonable time, Malas, in these affidavits.
What?
Malas, some geological, Malas, the fencing, etc., which are under process, Malas, as per the Union of India's Malas directions. So we are in the process of Malas getting them done, and Malas, we are asking some reasonable time before your lordships. Malas, grant me some time, Malas, to file it.
It's compliance report. Fine. 1 minute now.
Please.
Advocate on record, appearing on behalf of the state, submits it. This is the court had granted 2 weeks time. It was under an impression that you could file a compliance affidavit any time during the course of the day today. At least now the state ought to have been ready with the compliance affidavit. With that as it may, we carried the matter to be kept on 19th of March 2025. We clarify that any lethargy on the part of the state, this matter would not be taken lightly by this court. Paragraph. The permission of the learned amicus, where is that newspaper report? Worship again. The bottom of page 24, the last paragraph, they have pointed out other instances including permission. The learner has brought to our notice the report of the Comptroller and Auditor General of India on functioning of compulsory afforestation, fund management and planning authority. To bracket CAMPA for the year ended 31st of March 2022. Paragraph. In the said report, the CAG has pointed out various irregularities in the utilization of the CAMPA fund. It points out that a huge amount spent on inadmissible items. The report further shows that a huge amount is spent on state schemes like what is that Harela?
It's a function that is organized. It's a function that is organized.
Harela, Tiger Safari work, renovation of existing buildings, expenses on personal visits, court cases, purchases of iPhones, laptops, fridges, coolers, stationeries, etc. As a utilization of the Kampa fund for such inadvisable items is a very serious matter. We therefore direct
I think there is an add-on item. Where the Union is the part. The state government fees, it will not tax for 1 or 2 years, but then it earns
interest on their interest.
Was being from 1921, even though the state government requests the state government to state from time to time. State government access the funds that state government
Of the what is CAF Act compulsory afforestation fund, so as per funds of the compulsory afforestation funds act to bracket CAF Act. The state had to deposit the interest on the balance available under state compulsory afforestation funds to bracket records of state authority. Note that the state government did not discharge the interest liability of 275.34 crores for the period between 2019-20 to 21-22. It stated that even though the state authority had requested the state government for the same from time to time, the state has not been done. Report further shows that the government has accepted the state fact and stated the interest liability of rupees 150 crores has been deposited. And not depositing the interest as per the provisions of the Act with the cap. Very good. We therefore direct the Chief Secretary of the State to file an affidavit on these aspects by next date. Secretary would be here on 20th.
Manas, I am here, Manas.
Yes, we hope that you have heard the order.
Please. We will satisfy your lordship.
Satisfied now.
Manas,
This is the compliance report and you are saying that you will satisfy.
So, Malas, the last order says, Malas, we have to file by 5th, Malas.
Today is 5th March.
Any reasonable time, Malas. We are filing it today, Malas.
The list that is expected is that you should have come with the compliance report when the matter was being heard.
Malas, we are filing it today, Malas. We grant some more reasonable time. Since your lordships are taking on 19th, Malas.
Tell unko.
I am deeply obliged.
Or
the real matter, several minutes, 7 times. We are covered by the reporting.
yes, who is most threat of surrender?
Lady issue. She is there for the state.
Don't address this lady directly. It's not a. Yes, but have some decorum when you are addressing the board.
So, state is.
Yes, madam. Who is everybody for the state? Yes, the other co-actors has already been granted the evening.
Listed before the Honorable High Court for final hearing on 24th.
The letter for the state.
We are covered.
But that the matter is already fixed to a final hearing before the Uttarakhand High Court on 24th of March 2025. We therefore request the High Court to take up the appeal on the same date and oppose the matter.
Of 25, which is fine by that. The reproach will find once your lordship's clarification order dated 10 December 2024, page 45
Of the IA.
of that, page 45, let's say one, and 46. The grievance of the raised behalf of the review petition some of the applicants who spoke is that though they were in employment covered by the recognition order in also, they believe that the judgment and order dated 20th November would come in their way if they want to make better their prospects by applying other institutions of a promotion. We clarified in the judgment of the region that the one-time schemes provide solely safeguard the interests of those teachers who are employed on social leave. We are therefore not inclined to entertain the review petition for the distance certificate. However, to avoid confusion, we again clarified the 18 months diploma obtained by such persons who were in employment as on 10th August 17 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. Needless to state, the clarification will be effective from the date of pronouncement of the judgment under review. The date of the judgment under review is 28th November 2023. Now, the advertisement in question here is 29th May 2024. It's not that, it's 29th May 2024. And that was for 2,900 vacancies for which a recruitment advertisement. 29th May 24.
29th May 24.
And Jaiveer Service Principal Judgment is 28/11/23. So since this clarification applies from there, we have the right to be considered towards this advertisement and for the counseling processes that start. A similar issue grows with reference to Bihar,
You were in employment on 10th of August.
We were in employment in 2017, no cable on that count. It's admitted. We were in service and we have done the 18-month course as required by the timelines provided under the RTN. All that is not in this. Now, in Bihar, when the same issue arose, it came to this court, and if you lordship will see at page 52, just 10 days after your clarification out of 10th December, so 20th December. Implementation of the clarification. That's at page 52. And then 24 for recruitment so. Para 6. In the interim, you keep it appropriate to allow participation of the applicants in the counseling process being conducted by the BPS. The outcome of the counseling process, so far as the applicants are concerned, we can confident. After notice. Notice was issued in the transfer petition first, and then in this IA. The notice in this IA was on 19th February, after which they have filed a counter, the state. Now, in the counter at page 11, the state says that the counseling process 90% complete. Independently, we find an RTI and we find at page of the same application at page 95. You'll find there are 278 vacancies at the moment. I'm not talking about the pages of the reply. So that they can use. Just as of the same application, page 95, it's an RTI response. The relevant is at page 96. Bottom of page 96, very last row, it says total number of vacant posts. Last column is 278. So 278 is the number of vacancies. Now, before your lordships, I represent 239 of them. I believe that without in any way disturbing those who have already been counseled, etc., which I would be entitled to ask for, but I don't want to ask for that. Let's not disturb what's already happened. If you've counseled 90% of them, you have 278 present. We are just seeking implementation of your lordship's order. I have copies of a list. The KVs are done on 13th February, NCT has issued. People who have got the benefit of that. Now, at the very least, that should be implemented by the state. I don't know why they're dragging their feet.
My lords, I did not have the benefit of appearing before my lord. Clarification as to interpretation over the review order.
No, they are only seeking the implementation of our review order, which we have clarified by the review order. We did not entered in the review, but we clarified our order.
To the extent, my lords, as to what will be the interpretation, my lords, because the state will with the it's in compliance of the parent judgment. Who are the which basically service rules. My service rules are in consonance with the guidelines.
Therefore, we held that you did not have, maybe you did not have the benefit, but Mr. Sethi had the benefit of arguing that matter.
That's the matter now. I'm the
Yes, sir.
I've been back the matters and may not be able to
And
give
we
assistance.
yes, we upheld his arguments.
My lords, may kindly see para
Para 3.
However, to avoid any confusion, we again clarify that the 18 months diploma obtained by such persons who were in employment as on 10/8/2017 and who have completed the diploma course of 18 months would be treated as valid diploma holders for the purpose of applying in other institutions or for promotional avenues. So the purpose, my lords, my limited understanding is that it had to be for institutions or for promotional avenues. But at the same point in time, by the parent judgment, my lords upheld the rules as well. So my lords, the fresh counselling has happened as per the rules.
There are many vacancies to be filled by the state government, and they are already working in some institutions on a cut-off date, and they are tentatively considered for migration from one institute to another institute, or if they are in the state government for the purpose of promotional.
With respect to what already there, that any individual is removed. Because of the parent judgment. Please see my rules, my lords. My rules have been upheld. My lords must please see paragraph 15, my counter affidavit, and see the rules.
Madam, you have upheld, but for all purposes.
That's what I see my lord's clarification, since it said promotional avenues, which basically would have meant that in the second. My lords, may kindly see my limited submission. Would it also mean for the Uttarakhand government?
Yes.
That my lords, may kindly see. As I said, my lords, the judgment was passed by my lords, and I will be just rather it's the other way around. I am seeking my lord's assistance. My lords, may kindly see my counter affidavit.
We will provide you the necessary assistance.
My lords, guidance, a better word, my lords. But my lords, paragraph 14 and 15 is my counter affidavit, my lords.
Just limited to the vacancies which are left out now.
Was candid enough to
The process, if my limited understanding would be that if there are added to the pool, the list will have to be looked into.
even if you clarified under 142, not a binding on it.
Very good, my lords. Very good.
Why I don't know what has happened to state of Uttarakhand today.
My lords, may clarify, my lords. I'm just
We'll have to pass the a cumulative order inviting your chief secretary.
My lord, that will not need. My lord, I'm buttressed from the technicalities. However, if my lords are clarifying in order.
Just to help question, there is no examination, etc. It's just that if you're eligible, you come. Now, if they had a question of a glut of applicants, then there may be some issue they face. At the moment, there are 278 vacancies. We have 239. If Ms. Shukla is right, they will have to open the door and just appoint us. That's exactly what will. But these are
Appoint us if you are otherwise eligible. Otherwise eligible and we don't know. They might be having an interview process.
If you're not eligible, then the question doesn't arise.
That's right. That's not it. The applicants have approached this court for an election. Very good. What is the date of our judgment?
So judgment 28/11/23.
In order to provide one-time opportunity to such of August 2017 to get a qualification of a diploma course. We are also held that of 18 months, the diploma, the 18 months was specified in order to meet the deadline of appointing the teachers under the judgment was clear enough and it held that one-time scheme was provided solely to safeguard the interests of those teachers who were employed as on 10th of August 2017. The grievance of the petitioner is that though they have been, those they are eligible as per the original judgment of this court dated 20th of November 2023,
2024.
29th May 2024. That is known as the their claim. We submitted that. See, Narayan further submitted that. Narayan further submitted that. The information received under the Right to Information Act and the number of applicants is 265, 39. And the Narayan fairly stated that the applicants do not intend to effect the selection process. Ms. Vanshija Shukla is happening on behalf of which provided that the 2 years qualification was there's a diploma in education. Wanted as teacher. It further submitted that any interference at this stage would cause complications in the selection process already done. Correct. No doubt that we have followed the rules framed by the state government by our judgment dated 20th of November 2023. However, at the same time, we had clarified that such of the teachers who were already in employment on 10th of August 2017 would be entitled to the benefit of one-time scheme floated by the Union of India. And if they had completed, we held that such of the teachers who have completed the diploma course of 18 months would be treated as valid diploma holders, other institutions, or for promotion. Additionally, other institutions would also include the schools run by the state government. We find that the case of the president he opened the selection.
So the contempt will not be placed because now we're placing them. My Lord, it's just
So you can dispose of the, no. So this is a transfer application. So now, in your
maybe not.
way of saying, the main transfer is but this can remain time bound. The sale shall be done within a period of 3 months from today.
Little more time, my Lord's possibly granted because my Lord's
The session will start, but children have to study.
my Lord's
You can take care of this. If we final transfer application is also taken on board. In view of the opposite. Question of where there was a judgment of the High Court which we filed the SLP. The High Court judgment came prior to your Lordship's clarification, but after the advertisement. So the High Court judgment effectively followed what was the one double nine 43.1. 43.1, you know. Is the one essence. There are companion services. My name is 43.1. The recruitment notice is dated 29 September 2022. And that notice, in this case, included us, included DLED 18 months. Therefore, we were eligible, we applied, we participated. The challenge to that notification was taken over the process. That writ petition first went to the single judge, and the judgment was passed on 29th February 24, allowing their writ petitions against us. Went to DB 4th July 24, sustaining the single. So they had taken a view, contrary to the view taken by the Uttarakhand High Court. Yeah. So the process, a single judge decision. In my SLP, there are 388 in the SLP and 240 in the shipment. Makija is representing a larger number. All in 600 or 650 or something like that. And there are 2,200 vacancies as of now. We are totally 1,024 from what I understand, all of us put together, with Prasad, Siddhi, all of us put together. So we are seeking, Manoj, similarly, that because in both Bihar, that clarification has been understood properly. Today, your Lordship have clarified it for Uttarakhand, and Mr. Gupta's assistance was there before this court on that date, 10th December. I don't think there should be any cabin with this issue that we should be eligible and permitted to take part in the counselling. Now, the month, and we have taken part in the counselling. Our name doesn't feature finally in the select list, but our name should feature in the select list because we weren't completely eligible. The only question was eligibility, which we had. That's really the only issue that I had. One of the functions, the HCP has also issued a clarification. But how are you in employment in 2000? and those who achieved that qualification after a month or so. Both 24-month candidates, interstate between the 24-month candidates. There was an issue which was raised, which the High Court held against the people who did not have the 24-month qualification. And that has come up in an SLP. The matter has been heard and judgment has been reserved. Now, in that issue, it was dealing with the same advertisement. Different issue, same advertisement. In which this court passed an order on 29th January 2024, accommodating those from the 24-month DLF who had the qualification prior to the advertisement date. So 9,500 11,758. 750. So out of that 2,000 balance remains. We believe that we could be accommodated against that. I just want to know that. Who have been accommodated? Those who are having 18-month diploma or 24 months? Month was 24 months in that case. So there 24 months before date of advertisement have been accommodated 9,500. There is a small bunch who are achieved the 24 months after the date of the advertisement. The arguments I heard Mr. Gupta, I was there, it was heard, judgment has been reserved in that. I'm going to give you the full picture. So should we await? Judgment has been reserved. 24 months was 24 months. That doesn't have anything to do with 24 months. So there's no issue of 18 months there. That issue. That's what he said. Number of points. Not accommodation. Because there's no. That's correct. No, they have not. Was against us only the issue of campaign first, because only campaign first. Others is a clarified first. Therefore, it should be that's the short submission. Where the Calcutta High Court relies on Javin Manjula. Yes, yes. Page. There are in employment in 2011 on the top. I'm accepting your lordship's orders and the review order also. No question. But I've gone through the JV judgment also. But your lordship's recorded. And in your great detail, your lordship has gone through the entire process. And as I understand it, and we also well that 18 months was provided. Otherwise, 18 months is not an equivalent. Not an equivalent. But for the purpose of those persons who were in service, as a matter of fact, they were sent for that course by the state governments only. State government, at least in West Bengal, had no control over. They applied themselves. But the consequence is a little different. I'm only going to point it out to your lordship. It has lordship's order is to be given effect to now. There is no question. The consequence is this, my lord. For instance, if I take the petitioner, SLP petitioner, Mr. Kaushik Das, he claims that he was in employment for 2017. Now, we find that he has also disclosed death certificate at page 290 of 2022. So here is a person who under the NCT Act, under the RTE Act, section 23, would not have got employment in any institution because he couldn't have debt. I'm just giving an example. So therefore, my lord, we are now a little perturbed that there may be people in this batch who have somehow got some certificate from private unaided schools. So, my lord, what we are saying is, your lordship may remand the matter back. The persons will have to be verified because there is only one appellant before your lordship in the SLP. But, my lord, when my learned friend says 300 people, then, my lord, they are coming, my lord, as what we'll do, we'll hold that only such of the persons who are in employment on the cutoff date, they would be entitled to and that will be subject to verification by the authorities. That's as to whether they were in employment or not. That is whether they were validly in employment. Because my lord, we suspect now that private schools, my lord. So here in Uttarakhand also, We are not directed the blanket appointment. You have said that they will be only considered and if eligible,
Yes.
they are appointed.
Yes, correct. That is one aspect. 1,500 odd have been empaneled and appointments have been given. Some 8,700 odd appointments have been given. Now, in this Somenpal case, which my learned friend referred to, where Justice Narasimha and Justice Mishra's bench has heard us out, has heard everybody out, and only written submissions are to be filed. There, my lord, it was contended by the petitioners that the rest of the seats should be for their benefit. Now, my lord, your lordship may resolve this in any way that your lordship feels, because it should. Then there will be some hard fun there.
Just to respond to the TET aspect, that's a red herring that has been thrown by them, your lordships. As far as TET is concerned, 2017 was the notification. They held the examination in 21 and declared the results in 22. And even the now 9,000 persons who have been appointed, your lordships, a large number of them belong to the 22 exam. So that is.
Let me explain.
So that is a red herring which they are.
No, it is not a red herring.
Of course it is.
A person may take a TET examination in 2022 for future employment for the. No, I have not pulled up. Here to 2017, but I'm showing. So therefore, if that is so, then. Without a TET, which would be contrary to the legislation. Which is people like that.
No, so whether your rules require both diploma as well as TET.
Yes, no, it's not my rules. Now the RTE Act has made it compulsory that after a particular date, that is about 29th of July, you must have both the minimum diploma qualification and a.
Yeah, 17 and who are otherwise qualified, they would only be considered.
One point, I'm hesitating to bring it to your lordship's attention because it may have, your lordship would have taken it into consideration anyway. The amendment to the was for the benefit of people who were in employment on 31st of March 2015. Were in employment on 31st of March 2015, but had not been able to get the diploma, and they were actually given an opportunity this 18-month. I'm just bringing it to your lordship's attention. I do not know, Millard, whether this. The section says that if you are in this on 31st of March 2015, you must get all the minimum qualifications within 4 years' time. So 31st of March 2019 becomes the cutoff date for them. And this amendment is brought in August 2017, so there was only 18 months' time to get them qualified.
But now, therefore, we have already held that.
The first is with reference to petitioners before my lords.
No, there is only one petitioner before you.
That's what I'm answering.
Yeah.
So we will say that all such candidates who are we will pass an order in name not restricting it to the petitioner, otherwise we'll be flooded with and we'll say that the state would be entitled to consider their eligibility.
And so I want to respond on that because there is something to be said. This firstly, I think the correct
Mr. Gupta, I have the SLP here. There are 388 petitioners, SLP petitioners, 388. Starts from page 7 onwards, you can peruse it. There are 388 petitioners. Now, there are many who are pro forma respondents, that's different, but I'm just saying there are 388 petitioners. Now, the point that Mr. Gupta took was that, look, you did not have a tent on the date when you were in service and you achieved this 18-month DLED qualification. You actually were ineligible to have been an in-service teacher because you lacked a tent. That's what he's saying. If I understand that argument correctly, I was given only one. Density That's the third question which arises. Now let's not conflate that with this about whether those who are in the saddle in 2011 onwards, teachers who have been in service, all of now whether the teachers who were in the saddle in 2011 require the tent, was it absolutely mandatory? That question is at the moment sub judice. So for the state to endeavor in this case to bring this bogey up, Ms. Makhija is right, to bring this bogey up to create some confusion where you have, then we will have to await the outcome of that particular. What I'm suggesting is let's not get into to recall that when you dealt with the review petition, you dealt with a series of MAs. Two of those MAs specifically dealt with Bengal. This matter. The state filed a reply. And let me show you that your lordship didn't go into individual acts. 1 minute. Held you eligible to apply, but prior to you sitting for that 18-month course, your question of whether you could have continued as a teacher with or without a tent is a bogey, man. That I'm sorry. We have been in the saddle for 10 years, 20 years, 30 years. Today, after your lordship give this clarification, if your lordship were to employ the words that Mr. Gupta wants you to employ, which is to say that you should have been qualified prior to 18 months. That's all. System only subject to verification. Subject to verification. And subject to verification. Subject to verification. Because the facts of each individual has not been sorted. Subject to verification. Subject to verification as to whether they were legally appointed or not. That's all. That's absolutely.
Because this is what we are apprehending that the state will do, your lordships. Those who were registered for TET in 2017, because it is not my fault that I did not take the exam, they held it after 4 years. It is on their, it's their. So I am registered on 2017, exam held in 2021, result declared in 2022, and the persons who are already employed and given employment to are also 2017 TET candidates.
Correct, that's
so
correct.
That
9,000 that they've accommodated includes the 2022 TET.
Yes.
Then they shouldn't have accommodated this. They shouldn't have appointed this.
So this should not now come up as a second point of
after this course order directing them to appoint these 9,900, they will have to remove those people who have 2022 TET.
No, not to remove because 2022 TET they have taken now.
some reason.
Future recruitments they can use the TET. But is it not my learned friend's contention that they applied for and got a job without the TET? First they said government
orders similar to the Uttarakhand order. Well, let them verify and let's confirm.
check.
September 22.
Relevant for no, we are not going into date now. We are only going into as to whether you were appointed on a cut-off date, as to whether you are we don't want to get some certificate and all that.
Obviously, it is different and odd, but
by this honorable court in 2011, there are hundreds and hundreds of people started coming, filing affidavits saying that I was also qualified on 21. Here also, Milord, multiple implement applications.
How many petitions are there?
SLPs.
SSLP, there is one.
Yes,
We are already appointed. We are not going to discuss this.